Welcome everyone to the November Startup Know-How Talk. I'm Karen Utgoff, the Director of Venture Development. I'm here just to welcome everyone and to turn things over to Burnley Jaklevic, who's the Director of the Technology Transfer Office, and our wonderful speaker, Tani Chen. Burnley, take it away, please.
Okay, thanks, Karen. Hi, everyone. Welcome. We're really lucky to have Tani Chen here today, who's going to tell us about what every university researcher should know about intellectual property. And let me just advance the slide here. So a little bit about Tani. He is a shareholder at Greenfield and counsels clients in a wide variety of early stage technologies. He has a particular focus on helping small businesses and university researchers and enjoys working with startup companies. Prior to joining Greenfield, Tani was a research fellow at Harvard Medical School and Massachusetts General Hospital and Shriners Hospital for Children. And before that, he earned a Doctor of Science degree at MIT, where he studied technologies for drug delivery across human skin using a pulsed high voltage electric field. So without further ado, I'll stop sharing so that Tani can share his slides.
Thank you, Burnley. And let me see if I can share here. Okay, can everybody see my slides? Great. So thanks for coming. Thanks for inviting me to give this presentation. I'm going to be talking about IP and in particular patents and how this relates to university research and things of that nature. Starting with a little bit about myself. Burnley introduced me, but this is a little bit about my history. Came from MIT. I have a doctorate in chemical engineering there. I did a postdoc for 2 years at Mass General Hospital. Then after that, I've been doing patent law. So this is since 2001. So I've been doing patent law now for over 20 years. I went to law school at night, did the patent stuff during the day, was sworn in as an attorney in 2006. My practice in general focuses on early stage technologies. About half of it is university work and the other half of it is startup work. So basically two halves of the same coin. My technical background is in chemistry and biotech. There's a number of different areas I've worked in. As a firm, we actually handle pretty much any kind of technology you can imagine, but not surprisingly, we all have our specialties in our different particular subject areas where it's mechanical devices, electrical devices, or in my case, chemistry and biotech. And feel free to interrupt me if you have any questions or if you want me to explain something, or you can also send a chat as well. I like to start these talks by just analyzing the word intellectual property. Sort of my background as a scientist, I sort of have this tendency to take things apart. That kind of comes if you're a chemical engineer. So I like to take words apart as well. So if we look at intellectual property, it's got two words. Intellectual basically refers to things that are intangible. And property is sort of this weird concept in the law. It's really defined as a right to exclude others, or you can think of it as a barrier to entry. And I like to analogize this to real property and personal property, which are other major forms of property that exist in the law. So real property is real estate, land, buildings, things of that nature. And the thing to remember about it is, let's say you own a house, right? Well, that house is yours, whether you are actually in the house or you're not in the house. You might be at work, you might be at school, wherever, but that house is still yours. And even if you are not home, you still have the right to exclude other people from the house. You can keep people in your house, or you cannot have people in your house. If people come to your house and they're uninvited, whether you're there or not isn't the question. The question is, do you own the house? And if the answer is yes, you own the house, you have the right to kick people out of that house. So property isn't defined by what you hold as much as what you're allowed to keep other people from doing. It works the same way in intellectual property. And one thing to be clear is that there's actually a difference between intellectual property and patents. Patents is just basically one type of intellectual property, but there are others. Copyright is another one that a lot of you may be familiar with. Copyrights generally focus on creative works. So, for example, a movie is copyrighted, which means you can't just download the movie illegally. YouTube has a number of sort of barriers if you try to upload copyrighted material onto YouTube, etc., because it's all these sort of creative works, and people have the right to exclude people from using creative works. Trademark is another one that often comes up. It excludes the use of a mark in a way that confuses customers. So if you have a trademark to a hamburger, say your McDonald's, you can keep other companies that make hamburgers from using your particular branding. But the most common ones that you see in sort of the inventive areas and in technology and engineering is going to be patents. Your ability to exclude people from using invention. Another one that will often come up will be trade secrets, which is sort of the use of secret ideas. And if we have time, we can talk a little bit about that as well. So a patent in general. So again, there's this right to exclude. A patent basically gives you the right to exclude others from using your invention. So that includes making it, using it, selling it, offering it for sale, or importing the invention. Now, one thing that's always very complicated is that a patent doesn't allow you to do anything in and of itself. It basically only allows you the right to stop other people from doing things. And that can be important. It sounds a little bit weird, but that can be important because what you're really trying to do here is you're trying to protect a certain space that you want to operate in. So if you think about some of the philosophy behind this, patents are designed to protect investments, and that's kind of why they exist in the law, and that's why they're actually mentioned in the U.S. Constitution. I always think it's kind of interesting that, with all the other stuff going on when the country was founded, there's this big war with with the King of England, etc., that the founding fathers thought it was important enough to have patents that they wrote it right into the Constitution. There's a specific clause in the Constitution that says, Congress will create a patent system. And why is that? Well, it's because the patent system is what allows innovation to develop. It's basically, if you think about an invention that's donated to the public, right? You invent something, you have it in the lab, and you're like, well, I want everybody to use my invention. I'm just going to publish it in a scientific paper and donate it to the public. Anybody can use it. The problem with that is that often ends up in a situation where it doesn't attract any investment. Nobody wants to develop that technology because they're afraid of being ripped off as soon as they put any money into it. It costs a lot of money to turn something from an idea that's sort of on a lab scale to something that can be commercialized and people can actually use in the public. It requires R&D. It often will require some level of regulatory approval, whether it's a drug or if it's consumer protection or something along those lines. That costs a lot of time and money. And if you have to spend all this money and time to develop this new product, and then somebody comes along, copies your idea, and sells it at a much cheaper price, you're going to be afraid to go into that market. And then you're going to be afraid to go into there, and everybody thinks the same thing, and then nobody goes into that space, and then that idea basically never gets developed. So what the patents do, and again, this is what the founding fathers had in mind, is that you would give people who invented stuff a limited time to take advantage of their invention, and only they can use the invention. Nobody else can use it. And at the end of that time, everything that they invented becomes part of the public domain. Anybody can use it for whatever they want, etc. But there's this limited time where they will benefit, they will get money for their invention, and that specific amount of money is to be decided by the marketplace. But there's going to be some benefit for them to doing that and to developing technology. And the idea was, if we start doing that, maybe we can catch up with the superpowers of the world, which at the time were like England and France and those countries, and the U.S. was sort of an agricultural backwater that was a minor colony, and that's what they wanted to do to try to catch up. So you see a lot of this that sort of pervades into modern patent laws, this sort of basic idea. So let's talk a little bit about patentable invention. So what is an invention? I like to explain it as something new that no one has described before. And it has to be something that is new. So that means you can't find it anywhere in the literature. It can't be in the public domain. It can't be on the internet. And it has to be something that doesn't appear anywhere. And the reason it appears somewhere in the literature might be because of some other person, but it also might be because of you. If you describe it on the internet, the next day it's no longer an invention by definition because it's on the internet and everybody knows about it. And that's very important. It has to be new, and there's a lot of places where information can get out. And as soon as things get out from one of those channels, you run the risk of not having a patentable invention anymore. That's the first criteria. Is it new, or do other people know about it that aren't connected to you? It can be anywhere. It can be in the US, it can be on the internet, it can be in other countries. It doesn't have to be in English, but does somebody have that same idea that you did, or are you the first person to come up with that idea? It's sort of one thing that the patent office looks at. The other two are non-obviousness, which is something that it's got to be unpredictable, significantly different than what's been done before. It can't be just a minor gloss or a minor, I changed the color of this widget and it's somehow a different idea. You know, it has to be significantly different. And the third one is it has to be something that's practically useful. So this doesn't include things like mathematical formulas. It doesn't include things like movies and things of that nature. You know, again, the idea behind patents was always trying to protect sort of mechanical devices and things of that nature, and not more artistic endeavors or things like that. That became the realm of copyright, and that was actually a different part of the U.S. Constitution. One other thing that's important to note is if you kind of distill these rules down, and if you don't remember anything else, the most important thing is you must file your patent application before you have any sort of public disclosure. Once things go into the public domain, or in the modern world, once things end up on the internet, it's very, very difficult to get them back off the internet. It's very hard to take things out of the public domain. The law doesn't let you do that sort of thing. So you have to get these cases on file, whatever your new invention is. You know, and UMass and other places have systems to sort of help facilitate that process, but you have to get it on file at the patent office before you tell any person in the public about what you're doing. So I mentioned a bit about patentable inventions, and if you look at, you know, the patents that were filed in the early 1800s, of course, it was all mechanical devices because that's the only thing that existed. Over the years, the concept of devices and machines has broadened. So of course, it also includes electrical devices as well as mechanical devices. And sometimes it includes software. This is a little bit of a gray area, but there's some types of software applications that are still patentable, even with recent Supreme Court rulings. Another very broad category of patentable inventions are compositions of matter. Again, this is something that in the old days meant a chemical. I think the first patent that was filed had to do with fertilizer. But it's been brought into more modern things. So, you know, catalysts, vesicles, DNA, RNA, proteins, you know, it's still compositions of matter, even though obviously nobody knew what DNA was back in the day. And all the biotechnology, you know, involves various states of matter. And so those are fine for patenting. That also includes life forms, which is a little bit of an oddity. But the way, because you know, a life form is it's a composition of matter. It might be a living composition of matter, but it's still a composition of matter. And so it still generally qualifies as being patentable if you can meet some of the other criteria about being an invention and so forth. Besides these sort of things, there's also methods of making things, whether it's methods of making a composition of matter or methods of making a machine. And similarly, you can also patent methods of using it. So you use a machine in a particular way, or you use a composition of matter in a particular reaction, or what have you. There's a number of different sort of flavors of patents that are out there, of different type of things that you can file. The most common one, and the one most people run into, are known as utility patents. You know, we'll also talk a little bit about some of the other sort of things that are out there. But this is the one that people think of, right? When people say, I have an issued patent, most of the time they're talking about a utility patent. There's design patents, plan patents, and other varieties, but they tend to be pretty rare, and you almost never run into them. Utility patents are, you go to the patent office, you submit your patent application, usually with a patent attorney, and it becomes a negotiation process where you try to convince the patent office that you indeed invented something that's new and worthy of a patent. You know, sometimes you convince them that it's new, but they don't think it's worthy of a patent because they think it's too obvious, you know, and there's some issues of that you can run into. But generally, it's a negotiation that goes between the patent office and the attorneys, and that process is called prosecution. I always think prosecution is a little bit of an odd term because I always think of prosecution as putting people in jail, but that's what people call it, is the prosecution process. Once you convince the patent office that you've got something, it issues as a patent. Now you have your ability to stop other people from doing things, again, the right to exclude, and it's a limited time. It expires 20 years from your earliest filing date. So it's a little bit of a limited time, and within that time, you know, you hopefully are doing other things in a marketplace to capitalize on your patent. Hopefully selling product or things of that nature, and you know, that's how you're you know, taking advantage of the patent that you've been granted. Now let's say what happens is that you have this patent, you're selling your product, and some other company comes along and they start making a knockoff of your product, right? Well, you want to stop them, and what you do with that fundamentally is you file a lawsuit against them. You basically go to the court system. You say, I have an issued patent. This company is doing the things that are described in my patent. I want them to stop. That process is known as litigation. And that's why these two words come from. Patent prosecution is with the patent office. Patent litigation is with the courts. And people use these terms to sort of keep the two aspects separate from each other. Very rarely that people actually go to the point where they go to the court and the judge goes through everything. You hold the trial, and then the court issues an injunction and orders the other side to stop doing something. Usually what happens, especially for early stage companies, is that just the ability to threaten people that you're going to do that if they don't stop and negotiate with you is enough to get most people to come to the table. I think it's something like 1% of all patent actions actually go all the way to trial. Most of them settle because one side or the other realizes that they just don't have a winning hand, and they'd rather come to some sort of settlement rather than spend a lot of money on the patent lawyers. So that's sort of the patent process in general. Now, one of the things that can happen is that there's other things out there that look like patents but are not actually patents. One example is the patent office itself does this. They publish all applications they receive after 18 months. They publish everything they get, regardless of what the actual patent covers. And there's actually a pretty funny example somewhere in the system where somebody tried to patent the wheel, and the patent office published it because they're legally obligated to publish everything they receive after 18 months, regardless of what they think of the actual merits of it. And so they did that because they have to. And a lot of people sort of made fun of the patent office for doing that. But they didn't really have any choice in the matter. They have to publish everything they get, and it's important to realize that those are not patents. Another sort of related thing, again, are provisional applications. These are applications that can be filed with the patent office. They have a 1-year lifespan. They're important because they protect the filing date, but they don't start the 20-year clock in terms of how much patent protection you're going to get. Their value is in future rights. So it's important to think about these things, especially if money is tight and time is short. It's often important to take advantage of the system, and its value is in the future rights. One thing to be careful of with provisional applications, and this is something that there's a lot of misinformation out there on the web, is that because it's the foundation by which everything else is going to be judged. It's the foundation by which you're going to build the house. You don't really want to skip on this. It's something you do want to think about very carefully, make sure it's very adequately protected, make sure you've spoken, with the patent lawyers to try to help you work through all the pieces. But if you skimp on the foundation, then later when you try to come back and build the rest of your patent structure on it, you find that your foundation is weak, and that can be problematic. So it's not a situation where you file a picture of your napkin and think that you're going to get a lot of protection on it. It's something you want to work very carefully with a patent attorney on, to make sure that things are done the right way. Another thing that's worth mentioning here is that what we've been talking about so far are basically what happens in the US. And it turns out that most other countries have their own version of patents as well. They have their own patent offices, they have very similar rules, and their own procedures and their own patent lawyers and so on. And there's a system known as the Patent Cooperation Treaty that ties all these different patent offices together. It's this treaty that a number of countries around the world have signed onto. Pretty much most countries, including China, Europe, Japan, Australia, Canada, and so forth. And they have a system where you can file a certain type of patent application that will give you the ability to pursue your application in their country at a later date. So it's sort of an option for foreign filing is kind of how I explain it to folks. And it basically gives you 30 months from your initial filing date before you have to enter in all these different countries if you go through this PCT process. There's a number of legal obligations on it, which I won't get into today. But again, it's the kind of thing that you can work through with a patent attorney. What you typically do is you first file in the US, and then that gives you 1 year to get the PCT on file, which gives you another 1.5 years after that to go into different countries. For purposes of this discussion, Europe is typically counted as one country. And that 30 months is important because that basically gives you 2.5 years to figure out, what's going to be the economic value of your invention, where's your company going to be, What's your company's business model going to be? Who your likely customers are? Are they all going to be mostly in the US? Are they going to be mostly in Europe or China or so forth? And then you can get your patent protection tailored to cover all those things without having to spend a lot of money initially. And the other thing to remember is that patents are a local system in the sense that each government has its own patents. So if you have a US patent, it doesn't work in China. If you have a European patent, it doesn't work in Japan. So how do you go about getting a patent? Well, again, patents, if you want to think of it as it's kind of a bargain with the government. You have to tell the patent office certain things, and at the end of that, you get certain things back from the government. So the prosecution process, again, these are all the things you have to tell the patent office. You have a certain scope of protection that you want. These are called claims, and these are these sentences that you will find at the end of the patent. You have to explain what you've invented. This is known in the patent world as the written description, but it's basically describing everything you know about your invention. You have to describe it in a way that somebody can get kind of the same results as you did. They call this enablement in patent law. For those of you who are academics, this might be better known as reproducibility. But you have to describe it in a way that somebody can figure out what you've done and duplicate the thing that you're doing. And the other requirement is that you can't hide the best way you know how to do the invention, the thing that you've built. That's known as the best mode requirement. So you can see there's a lot of stuff you have to give up and tell the patent office and ultimately tell the world, what you've done. And that's how all this information goes into the public domain and into the marketplace. It's expensive. It can take several years. There's a lot of stuff here you have to get right. But in return for that, you get a patent and you get this right to exclude other people for this limited time before it all goes into public domain. During that time, again, you can litigate this or at least threaten litigation against potential competitors and things like that. It's a self-enforced right, meaning that there's no patent police. There's nobody out there that's going to assert your patent for you. You have to basically police the marketplace, figure out what your competitors are doing, keep an eye on them, and if they look like they're going in certain directions that you don't like, you have to think about what actions you might take to stop them, whether it's just approach them for a license or threaten some sort of litigation or what have you. And I have a number of clients where we do this on a regular basis, where we keep an eye on what our competitors are doing, both on Google and press releases and things like that, trade shows, what we hear them they're doing through the grapevine, as well as keeping an eye on what patents they're filing. And again, once all of this is done, all of this stuff becomes part of the public domain and anybody can use it for any purpose whatsoever. So I want to talk a little bit now more about patent strategy and less about the mechanical kind of things. The mechanical kind of things, again, are things you typically end up working with a patent attorney on to help you understand all the things and which forms you file and things like that. The next couple of slides are really more for when you're thinking about your company and your startup, what are the things you have to worry about? So one of them is patentability versus infringement. And these are two completely separate questions that everybody always gets confused. I mean, I remember getting these things very confused when I first started doing patent law. But they're two separate questions. And when you start talking to investors and things like that, they will often ask you both questions and expect that you will answer them, appropriately and not get them confused with each other. So the first one is patentability. Did I invent something? Do I have the ability to stop other people from doing the thing that I invented? Do I have enough space here that if I try to sell this product or whatever, that people will actually pay me money for selling this product to them? It's divided by the claims of your patent, these sentences at the end of the document. They have to describe something that's new, not obvious, that's useful, etc. Basically avoiding the prior art. You figure this out by working with the patent office, going through patent prosecution, and then ultimately when you're talking to investors, you're basically telling them, here are the things that I can stop other people from doing. Right now, the second question is the infringement question. Is my company's product or process going to be blocked if I try to sell it in the marketplace? And that's the entire product. So your product might be a single thing, or it might be a complicated device. If you think about something like a car, it's probably going to have a lot of different components to it. And the question is, this product that I plan to sell, could somebody sue me for patent infringement and stop me from launching it into the marketplace? Whether I have a patent or don't have a patent is kind of irrelevant. The question is, what claims do they have that they can stop people from doing? You don't actually go to the patent office for that. What you have to do is you have to kind of read the literature and find out, well, what claims do other people have and what can they stop people from doing? That's commonly known as a freedom to operate study. Sometimes people refer to it as a right to practice study. But in general, it's a question of what are your competitors doing? You know, the first question is, what are you doing? The second question is, what are your competitors doing? Whether you have infringement or not, ultimately it becomes a question for litigation in the courts if they want to sue you for patent infringement or they want to threaten you and keep you off the marketplace, right? That's not the patent office that's doing it. That's court litigation that's doing that. And it's their right to stop you. So that's kind of the other question that they'll ask. And you can't answer the infringement question by saying, oh, by the way, I have a patent that covers my device. You have to look at what your product is, not what your invention is. You know, and again, this is something that people often get confused, and it is worth speaking to an expert on if you don't quite understand some of these issues. So, you know, again, now if you think about it from the more global point of view, if you look at patentability and infringement, right, these are business tools. These are ways that you have of stopping competitors or ways that competitors have of stopping you. And it's not just a legal document that you file with the patent office. It's full of a lot of legalese that's hard to read, right? You know, why do people care about this? Why do investors ask what's your patent protection? What's your FTO position? You know, that sort of thing. It's because they're trying to figure out how valuable your business tools are, and are they going to be the kind of business tools that will protect their investment, or is it going to be something where they're at a lot of risk, and then therefore they might not be willing to invest in as much money in your company because they're afraid they're going to lose it all. So patents often will satisfy a lot of different purposes. It's not just for the judge to read or the jury to read in the litigation, but it's going to be the investors that might want to read it and understand what you have and what you can do. Your competitors are going to read it. As I mentioned, we spend a fair amount of time reading other people's patents and finding out what our competitors are up to. So yeah, we're reading these as well. Business partners, oftentimes a startup company will want to make some sort of partnership or strategic investment or something like that with a business partner, and one of the first things they're going to do is like, send us a copy of all your patents. We want to see, you know, what things you can protect and what things we would be protected on if we started to go into business with you. So as you can see, there's a lot of requirements here, both on the legal side and as well on the business side. And yes, you can file a patent by yourself, and a lot of people try to do that. But you know, in general, the advice is that you'd really want to hire a good IP attorney who understands these aspects. It's not just a technical aspect. You know, if your patent is protecting an investment, it's like it's a biotech company or something like that, you'd want somebody who understands biotechnology to help you, not somebody whose, you know, background might be in computer science or something like that. But besides the scientific and engineering aspects, you'd also want to make sure they understand the law, how you apply it, all of the nuances, and also how they understand the business strategy, and do they understand what your business goals are. Not all patents are the same, not all business goals are the same, and the right kind of patent might be different for a very large company than it would be for a startup. So one question that people often ask is, well, how much does a patent cost? Right, and you know, it's hard to give a straightforward answer to that. You know, I can tell you the median price in Boston, which is somewhere between $10,000 and $15,000. But patents, like a lot of other things in life, you know, you get what you pay for. If you want a cheap patent, you don't have to spend a lot of money. You can find patent lawyers who are willing to do a patent application for, you know, $1,000 or something like that. On the other hand, it might not be a great patent and it might not last that long. If you want something that's more quality than that, you know, you typically have to spend more money and get that level of protection. So in that respect, hiring a patent lawyer isn't any different than, you know, hiring a plumber or buying a car or anything else in our economy. You get what you pay for. A good patent lawyer is going to work with you, look at all these different pieces, the scientific piece, the legal piece, the technical piece, the business goals, and try to map out a strategy that makes sense, because you have to identify all these goals and make sure they're adequately protected. And it's important to have the business strategy, you know, and it's not just going to be you and your patent lawyer that's reading it, but it's going to be these partners and investors and other folks that I mentioned. And, you know, I have seen patents written by other people or written pro se, which means that without a patent lawyer involved, where they showed it to investors and they couldn't get anybody to invest in their company because the investors felt like it was too much of a risk to invest in the company. The patents were not valuable enough and not written competently. And I've seen companies fold. So it's something you have to be very careful of. Another thing to keep in mind is that a lot of these decisions you make are things that are basically impossible to fix later. Once something has been put onto the internet or somewhere in the public domain, it's basically impossible to get it back off of there. And that might be something that there's nothing you can do about it. And now you're stuck because what you thought you had an invention on is on the internet and there's not much you can do to take it back. So these are things that have to be done very carefully from the outset and not something that you try to come back later on. So that can be complicated, and it's important to think about these things strategically and sort of hire the right patent attorney that's going to help you, meet your goals. So a couple of takeaways, and then I'll open it up for any questions. I hope that I've discussed the idea that patents are actually important business tools, and it's important to think about them as more as a business tool than rather as a scientific paper about what I invented in the lab yesterday or something like that. It's a very high level strategic kind of thing that will affect a lot of aspects in a business. Therefore it has to be done correctly. There's a lot of technical and legal requirements. Again, if you don't remember anything else, you should remember that you should file a patent before you disclose anything to the public. Hopefully you do this with a good, competent IP lawyer that understands the science, the law, and the business. And again, you get what you pay for, so it's very wise to shop around and talk to different attorneys and see what kind of services you can get. When I used to give this talk in person, I used to offer a meeting up with people for free coffee if they wanted to ask me additional questions, sort of like on a one-on-one. Still happy to do that, although I'm not sure how you get coffee through Zoom. But other than that, I'm happy to answer any questions.
Thank you, Tani, for that great presentation. I guess I have one question to just kick us off, but others, please feel free to put questions in the chat or unmute yourself and ask a question.
Before you do that,
yeah.
Could you stop sharing your slides and so that we can see?
Sure. Let's see.
Okay, great. So Tani, a lot of good stuff there today, but what advice would you give to a new startup company with a limited patent budget? Is an international patent application necessary, or is protection in the US sufficient in some cases?
Yeah, it generally depends. The first thing I would say is that you should probably talk to a patent attorney and maybe talk to a number of them and find someone that's going to give good advice. In general, you do have that provisional patent application process I mentioned that gives you 1 year, and that's often a very important year in the outset, because even if you only file just a provisional, because of the PCT treaty, that gives you rights to file the internationally 1 year later without losing anything. So it's important to sort of have someone to help steer you through that and make decisions about when's the right time to file an international case. Some technologies, it doesn't make sense to file an international case. Although, these days I would say probably 90% of all applications get filed internationally because, the market opportunities in other countries are just too important to ignore, and investors will want to hear that you've been thinking about these things.
Right. Thank you. I have another question if you don't mind. What do you think about patenting? You talked about being able to patent methods. What do you think about patenting methods that are challenging to detect and enforce?
Yeah, it's a tough question. On the one hand, infringement, as I said, there's no patent police. You kind of have to figure out these things on your own. And if you have patents that cover things you can't detect, that can be difficult, right? You can say, well, I think this company is doing X and I want them to stop. But then what the judge asks you, well, how do you know that? And you're like, gee, I don't know, I'm just guessing, right? That's not good enough to let you into their factory and see what they're doing. So, you have to have some reasonable basis for accusing somebody of infringing your patents. And so that can be hard. On the other hand, there's some things that are a little bit more nebulous where it's not clear, there might be a way to show infringement that might be something that remains to be seen as the product develops. It might be something that investors are like, well, you know what, we may be able to figure this out, we may not, but there's enough of an uncertainty here and that we might be able to detect something that, let's file now, let's do the investment, let's do the R&D and see where it goes.
Okay, great. Thank you. I wondered if you could talk a little bit about, oh, wait, I'm going to let, it looks like Patrick has a question. So let's let him ask his question.
Yeah, great talk. So my working business, we're working on developing cell-based assays, and as the research progresses, we're adding different layers of complexity to the assay. So I guess my question is, how aggressive should we patent different iterations of the technology, or does it kind of depend on what we're actually integrating into the assay in between each step?
Yeah, that's a really good question. It's basically a screening assay, right?
Yes, exactly. Yeah.
I have a number of clients that do various screening kind of things, and it often comes down to the question of what is going to be your business model, because the answer to the business model question will help determine what it is that you need to protect and what is it that you might want to hide as a trade secret and keep other people from knowing that you're even doing. So, I have some companies where like what they really want to do is they don't really care about the screening assay. It's just a tool itself. What they want is the stuff that comes out the other end of the pipe, right? It's a new drug. It cures cancer, right? We're going to patent the drug that cures cancer. We're going to tell everybody about this drug because we want to get FDA approval for it. So yeah, we'll patent that, but we're not going to tell people how we discovered it, right? All that stuff is going to be secret. And if anybody asks, we're going to be like, we're not going to tell you how we figured this out.
Yeah. Okay.
There's other companies out there where they're basically selling devices that are used for screening. So it's not really a thing that the device that they're selling, the product that they're selling. It's the device that they're selling, and so it's a device that manipulates fluids in such and such a fashion, and it does these sort of things. In that respect, if you sold the device but you didn't patent the stuff, people would figure it out by taking apart your device, how your screening technique works, right? They're going to figure out some way of getting into the device. The cheapest way to do it is just simply buy it off the open market or buy it off of eBay or whatever, bring it to the lab, take it apart, boom, you've got exactly how the screening technique works. So at that point, yeah, you might as well file the patent on there because you're not going to get protection and you're not going to keep people from taking apart your device and buying it on eBay.
Yeah, that makes a ton of sense. Thank you so much.
So it looks like we have a question from Lynn in the chat. And she says, great talk, Tani. You mentioned it costs approximately $10,000 to $15,000 for a patent. I think you meant just to file a patent application. How much does it cost to go through the entire prosecution and get a patent issued? And how about foreign filings?
Yeah, no, that's a very good question. Yes, that's the cost to just prepare the application, and that cost can vary. One is how much, as I said, what you how much you're willing to spend and how much quality you want. And the other is how complicated the technology is, and so what I like to joke is that, it doesn't take as much paper to explain how a doorstop works to how the coronavirus vaccine works. Obviously, one of them is very simple. You can probably describe it in about 5 pages and say everything you need to know about a doorstop. You're not going to fit the coronavirus vaccine onto a 5-page, document, no matter how hard you try. It's just too complicated. So it's going to be more expensive, right? So that's the other thing that will change costs, is how complex your technology is. Once you file the patent, then you have to convince the patent office to grant you the patent. So again, we're just going to talk about the US for now. And it can cost a couple of $1,000s for each round you have an attorney go back and forth with the patent office. It typically takes, 2 to 5 rounds of back and forth with the patent office. It can be a few $1,000s, say, $3,000 or $4,000, somewhere in there. Again, it depends on the complexity of the technology and the complexity of the rejections that you're getting. I had some cases where you're patenting something in a wide open field. There just isn't that much prior art out there because it's such a new idea. And prosecution actually gets pretty easy because the examiner just can't find anything that looks close. On the other hand, if you're in a crowded space, like for example, the battery space right now, like you try to patent a lithium battery, you know how many patents out there have lithium batteries in it? Like hundreds and thousands. And so the patent office can find a lot of stuff and it can create a lot of trouble for you. And then you have to spend a lot of time explaining why it is you're different than the other 100,000 lithium battery patents that are out there. Same thing happens in foreign countries. Foreign countries, each country is basically operating independently of each other country. If you get a patent allowed in the US, the European examiner could care less, and vice versa. So you have to multiply these numbers by the number of countries you're pursuing the patent in. So if you want to, you're pursuing it in the US, Europe, China, and Japan, for example, yeah, you'd have to multiply all these numbers by 4.
Right. So patent costs are equivalent, you think, in other countries to the US costs?
To a first approximation.
Yeah.
Yeah, you can get into differences. Some countries charge more, some countries charge less, but to a first approximation, that's the easiest way to do it.
And I know in the US we have maintenance fees. Do other countries have those fees as well to keep the?
Yeah. So maintenance fees are basically property tax. Is kind of the way I explain it. It's property tax, but for IP. Most countries have some form of property tax. So if you have a patent, it's intellectual property, so it's property. And they'll charge you a certain tax per year, depends on the country. The US charges it every 4 years or so. Europe charges every year. Some countries like the US, they don't charge you until after the patent issues. So if you can't convince the patent office that you have a patent, at least you don't have to spend any tax on it. Other countries will charge you every year just to have it pending in the patent office, whether or not they're going to give it to you or not. So it becomes very complicated very quickly. And again, it's something you'd probably want to talk to a patent attorney on, because they'll end up giving you a pretty large discussion about, this country has it on this date and that country has it on that date, etc.
Okay, great, thank you. I wondered if you could talk a little bit about how you work with universities and university inventors. What does that process look like?
Yep. Yeah, so when I do university work, and again, probably about roughly half my practice is university work, I represent the university. I don't represent the company, or they might be trying to start a company or whatever. My interests are the interests of the university. And usually universities are interested in licensing their patent. Sometimes they want to license to one company, sometimes they want to license it to multiple companies. Some technologies, especially platform technologies, they might be looking at and saying, hey, you know what, there's probably at least 3 different industries that all might want a piece of this patent, and we want a patent application that we could conceivably show to all 3, and they'd be excited about it. So I'd be writing the application and talking to inventors with those kind of goals in mind of, we want to describe something that's very fundamental, that you might be able to use it for, the telecommunications industry, but you also might want to use it for the biotech industry, and so you want to have some discussion about how it's good for all these reasons. And then you draft your claims appropriately. So you might have multiple claims. Some of them are clearly telecommunication claims. Some of them are clearly biotech claims. Some of them are probably a little bit vague, etc. And that's how you draft the application. It'd be pretty broad and hopefully covering all of these future activities that might become startup companies or might get licensed or whatever. Especially with universities, this often becomes a little bit of a crystal ball problem, because, it looks great on the lab. You don't know how it works in reality. You're hoping that it'll get licensed at some future date, but at the date you're writing the application and, you're kind of rushing through it because they're going to publish it in 2 weeks. Right, you don't have perfect knowledge about what's going to happen in the future, and so you end up taking the best guess that you can and trying to hedge your bets accordingly. That's important, because sometimes when you're on the other end, you're a licensee and you're looking at one of these patent applications, there's a lot of stuff written in it that really isn't applicable to you, right? In my example, if you're a telecommunications company, well, a third of the application talked about biotech stuff, which you really don't care about. Right, and so your interests might be different than a university. The university might be like, yeah, we want to keep these claims in there at least until we get some licensees involved, and then maybe they'll tell us what they're interested in, and then maybe you'll have some sort of deal where the licensee, your telecommunications company will say, can we go after these claims? The university will probably be like, fine, we'll make some deal happen and we'll go after those first. But they have other interests in mind, and it might, while they're agreeing with you and filing the telecommunications industries, they might be talking to some biotech company and saying, hey, do you want to license this patent to cover your biotech product? So that's something to keep in mind, is that your interests as a startup and your interests as a university are not necessarily the same interests.
True, that's true. Are the inventors involved in every stage of the process, Tani? So are they involved in prosecution as well?
It depends on how much they want to be involved. There's some professors out there that'll be like, I don't care. My grad student wanted me to do this, but I don't really care. I just want the publications. I don't care about patents. And the grad student kind of runs with it, and the professor just like, tell me what to sign and don't bother me ever again. And then I've had other professors which are just the flip side, like, tell me everything about it. What can I do to help? Do you need this reference on this thing? Can I give you an opinion on what this examiner is saying? Can I help in some of the discussions with the examiners and participate in interviews and things like that? And if it's a university case, it's up to the university to decide. But in almost all situations, the university is like, if the professor wants to be that involved, we're going to do everything to help them, commercialize the technology and learn as much as they possibly can.
Great. I mean, I guess, sometimes we have first-time inventors that get really upset when they see that first office action. Would you have any advice
Yeah.
for them?
I was actually just talking to a fellow the other day at a Midwestern university, and it's his first time through. And I'm like, one of the things you got to remember is like the patent process is a lot like trying to get a scientific paper published. In many respects, instead of a reviewer, you have an examiner. But when you send it out, the reviewer takes a look at it and comes back with a bunch of comments. You almost never get it through on the first try. The thing that matters is what did the reviewer actually say. Sometimes it's minor stuff. There's a couple of typos on this page. I want to see an additional figure on this, right? And sometimes it's like, I don't believe anything you said. You need more experiments, right? Patent process kind of works similarly. You don't really know what you're going to get until the reviews come back. In this case, it's an examiner, but it's kind of the same thing. Sometimes it comes back and the office action has, there's a couple of typos in your claim. You need to fix those. And other times it'll be, here are 12 references that teach exactly the same thing that you did. Explain to me why it's different, right? And your mileage varies depending on what you've got.
Right. Another question for you. Are there common mistakes that startup founders make when it comes to intellectual property?
I'd say the two biggest ones are, one, they start talking about their invention before they've talked to a patent attorney and gotten it on file. And two, the other one is they mix up patentability and freedom to operate. And the issue there isn't that they mixed it up per se. Because again, they're easy to confuse. The issue is that they haven't done their homework, and the investors look at it like, this person doesn't understand this, and therefore I don't trust them to protect my investment. Right? They feel like they don't feel like that you have to get it perfect. They just feel like that you haven't done sufficient homework for them to feel comfortable working with you. And to me, that's a bigger mistake than the actual legal mistakes and all those ramifications. Which are, those are actually pretty easy to fix. But losing their credibility in front of an investor is much more difficult to fix.
Okay, that's great. Thank you. We have a few other questions here in the chat. How do startups protect their intellectual property when they have new web mobile applications?
Yeah, the web apps can be very, very tricky, and there's sort of two issues. One of them is just the software aspect of it is difficult. It's a gray area of the law, and it's been changing a lot. And the other is the time cycle with which things operate in the app world. If you think about tech patents, people measure time in years. It takes 10 to 20 years to get something through the FDA. You have to do the clinical trials. You have to do a lot of animal experimentation. These all take years. The patent process also takes years, and so that kind of makes sense. When you're talking about about an app, right? The cycle time on there is months, but it still takes years to get stuff through the patent office. And so by the time you've convinced the patent office you've got something, you may or may not even have a business model anymore. And so that's something to think about, even independent from all the legal issues, is, does this even make sense as a financial investment for my company? Again, there's not a clear answer to that. We represent a large number of software companies. They have very, very valuable IP, but it's a conversation that you should have before you sort of make a decision one way or the other. Is make sure you've talked to a patent attorney and gotten really good legal advice on what makes sense in your particular situation.
Great, thank you. We have another question. Can you talk about broad versus narrow claims in a patent?
Yeah, it's one of the things that's always interesting to me is that the terms broad and narrow are always somewhat relative. What's a broad claim? What's a narrow claim? Well, I can't just look at a claim and tell you it's broad or narrow, right? Just like same thing with a desk. I can't tell you if a desk is broad or narrow. The only way I can tell it's broad or narrow is I have to compare it to other desks. Right. Claims are kind of the same way, and different claims in different industries are going to be different. A broad claim in the lithium-ion battery field, for example, might still be something that takes up half a page because there's a lot of stuff that's out there. Whereas, something in, the coronavirus vaccine space is probably, you don't need as many words to describe the thing that's new and different than what everybody's done before because it's such a new technology.
Right.
So, oftentimes, when you're talking to investors and things at the early stage, what you're really saying isn't whether the claims are broad or narrow per se. It's really, does this patent application have what it takes to keep other people out of this market space? Or is it something that they're going to park right next to what you're doing and they're going to sell exactly the same thing you're selling, but they change one minor thing, right? That's the thing that they worry about. And if you sort of say, well, we have broad claims and they're not going to even get close to anything that we're doing, that's really what they want to hear. And that's the thing that your patent application needs to show.
Right. We have another question. In terms of filing for provisional, how much protection would you have with it? And also how early on in the idea and research process should you try and attain one?
Yeah. I guess the second question there's sort of an optimum time for it, right? Because if you file too early, you don't have enough of an understanding of how the invention works, which basically means you've failed the reproducibility standard. And so that can be problematic if you try to file it too early and you can't really describe what your invention does and how it works. On the other hand, if you wait too long, there's a lot of competition out there. There's a lot of labs doing similar things. People worry about being scooped, and if you wait too long, you might be scooped, or somebody in your lab might accidentally spill the beans and create problems for you that way. And so there comes a time where you know enough about what's going on and it feels right to file it. That said, that those factors vary by industry. Some industries, they like to talk, other industries, they don't. Things that require a great deal of experimentation, there's a lot less fear of people accidentally inventing the same thing in their garage, that sort of thing.
Mhm.
But again, you'd probably want to work with a patent attorney and have them tell you when they feel like it's the right time to file, and when it might need a little bit more time to develop.
Okay, great. And then I just have one other question about, you talked about making a public disclosure.
Mm-hmm.
What if someone does make a public disclosure? What are their options, if any?
Well, unfortunately, there are not a lot of great options. It becomes a question of what did they disclose and when did they disclose it. The US used to have a 1-year grace period. It still has a 1-year grace period from the disclosure time point, but it's been cut back somewhat. So it's not as useful as it once was, although if you're lucky, you might be in the right situation where it is useful for you. And, again, there's a number of factors that go into that, which is a little complicated to explain. Most other countries around the world have an absolute novelty standard, which basically means the instant it's disclosed, you're kind of out of luck, and there's really no takebacks. Europe, for example, is a country that's absolutely, the instant it's disclosed, you're done. There's very little you can do at that point to sort of file something after that point and say that you invented it before that point. So, again, it's something you have to be very careful of and something that's very difficult to fix. I said it was unfixable. That isn't completely true. To a first order approximation, yeah, it is true. There are a few nuances and a few things you can do, but you'd have to work with a patent attorney to see if any of those apply to you and if you kind of luck out and one of those exceptions might apply to you.
Okay, so it's always better to file before you publish.
Right.
Okay. Great. Well, we're at the end of the hour, and if no one has any other questions, then I think that is it. Karen, do you have any other parting thoughts?
Well, I have many additional questions, and we're looking forward to having another session in the future. But I just want to say thank you. This was, I thought, a great discussion, and I'm going to stop the recording.
Yes, thank you, Tani.
Thank you. Yeah, and if anybody has any other questions,